A very warm welcome to all present here. On behalf of Adhivakta Parishad, Supreme Court Unit, it is my privilege to welcome you to this important discussion under the Justice S. Parvatha Rao Lecture Series. We begin this evening with the introduction of ABAP, and that is the Akhil Bharatiya Adhivakta Parishad, and to the Justice S. Parvatha Rao Lecture Series. May I now invite Sri Santosh Kumar, our Joint General Secretary, Akhil Bharatiya Adhivakta Parishad, to kindly deliver the introductory remarks. Santosh ji, please.
नमस्ते। नमस्ते। हमारे बीच में रिटायर्ड जज सुप्रीम कोर्ट अभय एस योग जी, उन्होंने जस्टिस बोलने से मना किया है फिर भी एज ए ग्रेस। और हमारे सुप्रीम कोर्ट के यूनिट के अध्यक्ष सीनियर एडवोकेट विनय नावरे सर और आदित्य कश्यप जी, लिटिगेशन आउटरीच इंचार्ज हैं। और इन, मैं इन सबको और व्यूअर्स जो भी हम ऑनलाइन देख रहे हैं उन सबको नमस्कार। अखिल भारतीय अधिवक्ता परिषद इज ए ऑल इंडिया ऑर्गेनाइजेशन ऑफ एडवोकेट्स rooted in the idea that the legal profession must serve not only the court but also nation and society. From a small seed planted in 1992, it has today grown into a truly national forum with the presence from the Supreme Court to High Court, District Court, Tribunal, on even talukas, subdivision levels across the country. Our motto is Nyaya Mam Dharma. Justice is my Dharma. This is not merely a slogan. It reflects our belief that advocacy is not just a profession, it is a responsibility. An advocate is not only a representative of clients, but also a guardian of justice, social balance, and constitutional order. The inspiration behind Adhivakta Parishad was the need to nurture both professional excellence and national spirit among the lawyers. A competent and social consciousness advocate become a force of positive change. With that vision, the Parishad has worked continuously to strengthen legal awareness for professional capacity, professional capacity and commitment to national developments. Over a year, the lawyer associated with the Parishad have fought for the rights of the neglected and the voiceless, including the Vanvasi, fishermen, street vendor, farmers, temples committees, and other vulnerable section of society. The effort has always been ensure that justice is not confined to a privileged few but reaches the last person in the society. A major strength of the Parishad has been its study circle, workshop, seminar, training initiative for the young lawyers. These platforms help advocates engage with the statute, case law, and contemporary issue, while also sharpening professional skill and ethical commitment. The Parishad has also taken just to the grassroots through Nyaya Kendra, offering free legal aid in the villages, remote areas, and urban slum. At the same time, Adhivakta Parishad has contributed to wider conversation on legal reforms, including Indian language in the courts, better judicial infrastructure, women's participation in the bar and bench, and other larger goal of the decolonization the Indian legal system. Through discussion, intervention, and the constructive engagement, it seeks to make a justice more accessible, affordable, and people-centric. Today, I am inviting all of the legal fraternity to connect with this mission to contribute not only as a professional but as nation builders committed to the justice. Namaste.
Thank you very much, Santosh sir. Now, moving ahead, and also thank you for setting the context so meaningfully why we are congregating today. So, respected chief guests, our guest of honor, distinguished members of the bar, learned friends, and dear participants. So the evening's theme is going to the heart of judicial ethics, institutional dignity, and public confidence in the administration of justice. So the question before us today is not merely whether a retired judge can do something as a matter of legal freedom. The issue is whether certain post-retirement assignments are compatible with the moral authority of the judicial office itself. Recent public debate, as we have seen in the various extradition matters that are ongoing abroad, they have brought into sharp focus the issue of former judges appearing in foreign courts and proceedings in ways that are being seen as weakening India's sovereign legal position. So that debate has now moved beyond isolated incidents. It has now become a serious institutional conversation about propriety, about restraint, about accountability, and the continuing moral weight even after retirement. Hence, the topic comes judicial robes cannot be rented. So, it is in this context that today's lecture becomes especially timely and necessary. Our chief guest this evening is Honorable Mr. Justice Abhay S. Oka, former Judge, Supreme Court of India. Justice Oka needs no introduction. Still, for the sake of our audience, I have the pleasure to introduce Sir. Justice Oka was born on 25th May 1960, did his BSc LLM from University of Bombay. He was enrolled as an advocate on 20th of June 1983. Sir started his practice in Thane District Court in the chamber of his father, Srinivas W. Oka. In 1985-86, Sir joined the chamber of Sri V.P. Tipnis, a former judge of the Bombay High Court and former Lokayukt. Sir also appeared in several important matters in public interest litigations. Sir was elevated as an additional judge of the Bombay High Court on 29th August 2003. Sir was appointed a permanent judge from 12th May November 2005. Sir took his oath as the Chief Justice of High Court of Karnataka on 10th May 2019, and Sir took oath as Judge of Supreme Court of India on 31st August 2021. I welcome Sir once again. Justice Oka is widely respected for his clarity of thought, constitutional commitment, deep concern for liberty, and unwavering fidelity to the rule of law. Sir's address on a theme such as this carries special significance because the issue ultimately concerns not only individual conduct but also the credibility and moral discipline of institutions. We are also honored to have with us our guest of honor, Sri Vinay Navare sir, Senior Advocate and President of Adhivakta Parishad Supreme Court Unit. Navare sir is a highly regarded member of the bar whose presence adds both depth as well as perspective to this evening's deliberations. A brief introduction about Sir as well. Sir started practice in 1988 and joined the chamber of Sri B.P. Apte. Sir completed his LLM from Bombay University and did part-time teaching in business law for 4 years. Sir finally shifted his practice to Supreme Court in August 2004 and was designated as a senior advocate in 2019 by the Supreme Court. I welcome Sir again. Friends, today's discussion is not about personalities, it is about principles. So it is about whether constitutional office leaves behind merely memory or also an enduring ethical obligation. It is also about whether institutional trust once earned through judicial office may later be privately deployed in ways that diminish that very institution. And it is about how the Republic ought to respond with restraint, with seriousness and clarity. So the Adhivakta Parishad in this background also passed a resolution on 5th April 2026, which also reflects that concerns and calls for a formal code and accountability structure for former judges. Now it is my proud privilege to invite our chief guest, Honorable Mr. Justice Abhay S. Oka, to deliver his remarks. Sir, please.
Namaskar and good evening. Shri Vinay ji Navare, Senior Advocate and President of Adhivakta Parishad Supreme Court Unit. On personal note, I must say that we are colleague advocates in Bombay High Court and we had opposed each other in many matters. Other office bearers of Adhivakta Parishad, senior members of the bar, and other participants of today's event. When one becomes a judge of a court, any court, and in particular High Court and Supreme Court, apart from Bangalore principles, apart from any other written norms, the judges are bound by several constraints and restrictions. Obviously, all those restrictions come in for the purposes of maintaining dignity of the office and upholding the old principle that justice should not only be done, but it should be manifestly seen to be done. And whether Bangalore principles or not, we are bound by those constraints. For example, if as a sitting judge, I was invited by Adhivakta Parishad to speak on its platform, I would have politely said no, because my belief was Adhivakta Parishad does have political inclinations. When a judge demits office, of course, he is not bound by those strict constraints and restrictions which he had as a judge. But I personally believe that being a retired judge of Constitutional Court, he must follow certain restraints and constraints. Firstly, talking about today's subject, I'll express my personal views. There are cases of fugitive offenders or fugitive accused. These are the people who don't want to face trial in Indian courts, and therefore they manage to escape out of the country, and that leads to Government of India or any other authority applying for their extradition before the competent court. If such a person who has escaped from India as he doesn't want to face trial seeks opinion of a retired judge in his favor, my personal view is that considering the dignity of the office which the judges hold, the retired judges should not accept the assignment. That is my personal view. Somebody may have quarrel with this personal view. I'll make a distinction. Take a hypothetical case. There is an application for extradition filed by Government of India in which a court in foreign country wants opinion of expert in India. He may be a senior lawyer, he may be a retired judge. In such a case, I believe that when court seeks assistance, there is nothing wrong if retired judge expresses his opinion and gives a truthful version of legal system in India before the court in foreign country. I am telling you about a case where the court wants presence of a retired judge. Now, why this controversy arose? There are judges, retired judges of the High Court and Supreme Court, who have deposed in such proceedings at the instance of the accused in the past. I know 3 cases, including the present case of Mr. Nirav Modi. If I am not wrong, in all 3 cases, the opinion expressed by the judges who were invited by the accused was not accepted by the courts. Having said that, and having seen that a retired judge gave his opinion on the request made by the accused in appeal arising out of extradition proceedings, we must also examine what exactly the retired judge has said. Unfortunately, the entire text of the opinion or deposition, whatever name it is called, is not available. I must tell you how the controversy arose. I have perused judgment of 25th of March 26 of the High Court King's Bench Division. That is in the case of Nirav Modi. It appears that a request for extradition was made by Government of India. In 2021, the concerned district judge held that there was no bar to extradition and he referred the case to Secretary of State for further action. An appeal was preferred by the accused before the High Court. In 2022, the appeal was dismissed. Thereafter, another judgment was rendered by King's Bench of the High Court in the case of Sanjay Bhandari. Based on that judgment, Mr. Nirav Modi appears to have sought reconsideration of the judgment in his appeal. As I said, a retired judge of the Supreme Court gave his opinion. From whatever is mentioned in the judgment, firstly, the retired judge seems to have said that once the authority of retired judge seems to have said that authority of courts in UK will come to an end after ordering or approving extradition, and then rest of the things will have to be done by the Indian authorities. And the second opinion which he expressed is quoted in the judgment. I am talking about judgment delivered on 25th of March 26 in application made by Mr. Nirav Modi for reconsideration of earlier judgment. Now his opinion is about the assurances given by the government of India or the investigating agency. They had given certain assurances that in what manner he will be kept in jail, he will not be interrogated by certain agencies, etc. All that the retired judge says is that the assurance in Mr. Modi's case therefore appears to be diplomatic promise rather than a legally enforceable formal assurance in India. So his comment is that the assurance given by the Indian agencies or government of India is not enforceable promise, but it is some kind of a diplomatic promise. Apart from that, I don't find any reference to anything adverse said by the judge about the Indian legal system. And ultimately, the High Court says that it is not necessary to reopen the decision in the appeal. Now, then comes Bhandari's case, on the basis of which Mr. Modi applied for reopening of his case in appeal. Now, in that case, I think there were two issues which were ultimately held by the appeal court, the High Court, in favor of Mr. Bhandari. The first issue was High Court was concerned with reverse burden of proof which Mr. Bhandari will have to face if he is forced to face trial in India. And secondly, the court takes a note of the fact that there was gang war in Tihar jail between the two groups. And therefore, concern is expressed about safety if the accused was kept in Tihar jail. Now, in this case, it appears that the same retired Supreme Court judge who deposed in the case of Mr. Modi, it can be seen from paragraph 158 of that judgment, all that he has done is told the factual aspects about jails in India on the basis of report of National Crime Records Bureau of Ministry of Home Affairs. The statistics was officially published, and that statistics is quoted by the learned retired judge, which brings on the record quite disturbing facts. It gives figures of deaths in prison in the years 2018, 19, and 20. And the figures given indicate that at least 10% of the deaths which occurred in jail were unnatural deaths. And in 2020, out of 1887 deaths, 189 were unnatural deaths. And it also records that 156 inmates committed suicide, 8 inmates were murdered by other inmates, 5 inmates died due to firing, and 3 inmates died due to assault by outside elements. So what is pointed out by the learned judge is a factual aspect based on the data compiled by Ministry of Home Affairs. Whether the judge should have responded to the request of this fugitive person or not, I express my opinion, he should not have. but he seems to have given facts about what happens in Indian jails based on the record of the government of India. Secondly, he speaks something about possibility of accused getting bail. Perhaps the case was under PMLA. Any case, in Bhandari's case, while accepting the case of Bhandari on 2 points, the High Court says that the retired judge of Indian Supreme Court has given contradicted evidence as to whether the court retained discretion to grant bail. That's what the finding is. Since this organization of the lawyers, before we say that strict action should be taken against this judge, he should be deprived of his pensionary benefits, etc., we must get copy of the opinion, entire opinion given by the judge, and find out whether the judge has given distorted version before the British court. I find from both the judgments that one is his opinion about possibility of getting bail, and that opinion is criticized in Bhandari's case by the High Court. And in the other case, the judge deposes on the basis of data published by the government of India itself. So when we discuss this issue, I also feel that all of us belong to legal fraternity. We must objectively examine whether the retired judge has said something which is absolutely wrong. Now, with this, I personally feel that why this is happening, that somebody is facing a trial in India, he lands up in foreign country, government applies for extradition, and then many things are said about the Indian legal system. We all belong to legal fraternity. Therefore, this is not a place to discuss issue of nationalism or patriotism. We must study why people are criticizing our system. One example which I gave, so many deaths, so many unnatural deaths happening in prison. And that indicates, the official figures indicate that there are fights between two groups of prisoners in our prisons. So I believe that when we discuss this issue of a picture being projected about the reality of Indian legal system, we must also make introspection, because that is required. The real challenge before us is that we should bring about reforms in our judicial system so that our system is not criticized in foreign courts, and therefore we must understand where we are going wrong. I am going to highlight only 3 or 4 points. Before I do that, I want to highlight only, I'll start with bail. It's a matter of record. If you peruse the judgments of the High Courts and Supreme Court, it's a matter of record that in many cases where in law persons were entitled to bail, they are denied bail, and perhaps they had to reach the Supreme Court. Secondly, there are many cases where we find that investigating agencies detain accused and they have to undergo pre-trial incarceration in such a manner that it becomes punishment without trial. These are the harsh realities which we say. We also see another harsh reality about condition of our prisons. I had occasion to visit some of the prisons in Maharashtra, chairperson of the State Legal Services Authority. All prisons in bigger cities face problem of overcrowding. As all of us know, though liberty of a person who is detained in jail is taken away to an extent, he is not deprived of all his rights under Article 21. So there are issues about the manner in which the investigating agencies conduct investigation, manner in which people are implicated, manner in which people are denied bail. Only one area where I always say when I visit law schools about the trials of criminal cases in India. One feature which we do not really project is fairness. the procedural fairness in our trials. And therefore, I always say that our trials are conducted in fair manner, and therefore even Ajmal Kasab was given a very fair trial up to Supreme Court. Very often, our citizens criticize long trial which was conducted about offenses concerning Bombay bomb blast of 91-92. Trial went on for 12 or 13 years. But why it happened, nobody examines. During the course of trial, certain additional accused were picked up by the police, they were produced before the court, and therefore rules of fairness required the learned judge to reopen the trial to recall the witnesses who were already examined. If you peruse the record of that trial, the statements under section 313 of the accused run into more than 6,500 pages. Every circumstance appearing in the evidence is put to the accused. Please imagine how many days and months the judge must have spent in preparing questions which are put to the accused. So one thing which is positive, which we don't say at international level, is the inbuilt fairness in procedure which were adopted under CRPC and under the new law. That is something which we never highlight. Apart from very serious issues which we are facing about long incarceration of under trial prisoners, poor conditions of prisons, denial of bail in cases where bail should be granted, there are two glaring issues which our legal system must address. Not in the case which we are discussing today, but I have seen in other jurisdictions, courts in India are being criticized for long delay in trials. Ultimately, when we talk about legal system, firstly, we must talk about trial and district courts. Now, why that is happening? The answer is very simple. In 2002, Supreme Court passed an order that within 5 years, judge to population ratio in India should be 50 per million, 50 judges per population of 10 lakhs. Today, we are struggling at 22 or 23 after 24 years of the Supreme Court order. In the meanwhile, population has increased. New category of cases have come up. Filing has increased. Now, this very elementary issue, we are not able to address. I am sorry to say this. I have been pleading this not only in my judgments, but also on public platforms as a judge. Nobody has taken this very seriously. If in 2007 required just to population ratio was 50, and today in 2026 we have 22, there are bound to be delays, inordinate delays. Now, this is an area where the Bar Council, the bar associations, organizations like this organization, Adhivakta Parishad, should be taking very seriously and asking questions to the governments why this is not happening. Unless we have proper just to population ratio, our legal system will continue to face criticism. Now, we have to seriously think about it, because today some judge has deposed. Tomorrow, some British court or foreign court will go on National Judicial Data Grid and will record in the judgment how the trials are getting delayed in India, because that is all matter of public domain. So this is area of concern. When we criticize retired judges, we must ensure that our house is set in order. Second issue is about pendency of cases in high courts. I can say this with great responsibility. Today, the scenario is when Chief Justices of the High Court request a successful lawyer to accept judgeship, there is a great deal of hesitation. And why is that hesitation? The reason is long delay in deciding on the fate of those candidates after the Supreme Court Collegium recommends the candidate. There are cases and cases where the government has taken 9 months, 11 months, 12 months, or even more than that to deal with Supreme Court Collegium recommendations. Now, the entire functioning of the Collegium is on the public domain. It was put last year. Now, before the case comes to Supreme Court, there are recommendations or objections of Chief Minister of the state and Governor of the state. There is a full-fledged IB report. IB is controlled by the Government of India. There are views of the central government. And all this material comes before the Supreme Court Collegium. Supreme Court Collegium considers it. And then look at the delay, 9 months, 11 months, 12 months. And what is the effect? The moment Supreme Court Collegium publishes resolution, the flow of work stops. A lawyer who is in the age group of 45 to 50 virtually has to stop his practice. He is forced to stop his practice because why litigant would come to such a lawyer whose name has been recommended? Only one example I'll give of Karnataka. A very eminent young lawyer was recommended. He had to wait for 1 year. There was reiteration. And unfortunately, after more than 1 year, he showed patience for 1 year. And ultimately, he took a call and said that I want to withdraw my recommendation. Now, this is one area which gives very bad name to Indian legal system. And another example, recently, in case of one High Court, from the date of High Court Collegium recommendation till the date of warrant, it took less than 4 months. This is exceptional case. If this happens as a rule, it will be most welcome. In some cases, certain candidates are directly appointed as permanent judges. In some cases, they are appointed additional judges. We need to work on this system because I repeat, that today the Chief Justice of the High Court find it difficult to convince successful lawyers to accept judgeship. Of course, I must clarify that still there are few successful lawyers, notwithstanding the fact that they know that they will be faced with uncertainty, still give consent. But some of them are forced to withdraw their consent because they can't wait for more than 1 year and 1.5 years. Third and important aspect where we have to really work hard, very often a comment is made about poor infrastructure of our judiciary. There are some states where infrastructure is good, some districts it may be good, but generally infrastructure is poor. That is where we want to work. We must work on these aspects. And this has, what I said, has direct correlation with today's subject. Because why people are tempted to say something against the Indian legal system? Because there are facts which glare at the face. Tomorrow, occasion arises if a retired judge is requested to appear by the court and not by the party in foreign country. I mean, he will have to give a truthful version of the Indian legal system. I'm not saying that everything is negative. As I said, fairness of criminal trial. Very rarely you'll find in any other country the procedure which we have. We have judges who work very hard. We have judges who work after the office hours. But what I have told you are the glaring facts which affect the image of the judicial system. To conclude, and I must say, I must add why I'm saying this, because I am on platform of Adhivakta Parishad. Perhaps Adhivakta Parishad will be in better position to persuade the ruling party to act upon these two aspects. First is increase just to population ratio, and secondly, bring some certainty, some timelines in appointment of judges of the High Court, and thirdly, give better infrastructure to judiciary. So Adhivakta Parishad will be in better position than many other organizations to take up these issues. And I'm sure, considering the people who are at the helm of the affairs, they will do it. Coming back to the topic, I want to end by saying that if somebody says that retired judges of the constitutional courts should not accept invite of these fugitive offenders, I personally feel that they are right, because even after we demit office, we are bound by the constraints. But we should not take extreme position without examining what the retired judges have deposed. We should not take extreme position that they should be deprived of their pensionary benefits, etc. There's a resolution says that no retired judge of the High Court or Supreme Court should use the prefix justice, and personally I agree with that. There's no quarrel about this proposition. So I must thank Adhivakta Parishad for taking up this issue, but this issue requires a lot of debate. And again, I say before I conclude that it is not sufficient to criticize the retired judges who go and depose at the request of the offenders. What is more important is to take immediate steps to improve the functioning of judiciary in India. And that is going to be the biggest challenge before us. I think my time is over. I again thank the organizers for giving me this opportunity. Thank you.
Thank you so much, sir, for your insightful address, which spanned across cross sections of the issues that the judiciary is facing, as well as the topic we had for discussion this evening. Before we go ahead, I would just like to seek sir's permission to inform our audience, as well as just to bring to sir's notice that last year on 26th and 28th December 2025, we had our national conference of Akhil Bharatiya Adhivakta Parishad in Balotra, wherein the resolution number 1 that we passed was with respect to strengthening the justice delivery system through timely judicial appointments. So we extracted all the data, male-female ratio of judges as well, and what is the pendency ratios that is there. So all of that taking into consideration. So we said that the members note with concern that the situation is aggravated by persistent vacancies in High Court, which as on date is around 26% of the sanction strength. So we took all of that in consideration and we passed this resolution, wherein we made certain recommendations, and as was resolved by the All India body of the Adhivakta Parishad. So Adhivakta Parishad keeps on working on all of these issues that the bar, the bench, and the common man, the common person who is at the last rung of the society, what they are facing, whether access to justice is being enabled, and whether they are the Vanvasis, the fishermen, so all of them, the street vendors, as Santoshji rightly remarked. So we are trying to reach to them and to ensure that justice is made accessible to them. Now I would just like to invite our guest of honor, Sri Vinay Navare sir, for his address. Sir.
In the first, in the first place, I thank Mr. Justice Abhay S for his insight on the subject. I also extend my gratitude for his agreeing to be a speaker on this subject on the forum or on the dais of the Adhivakta Parishad. Although he said that as a judge he would not have accepted, I would have tried to persuade him even during those days to address on some appropriate issues, but that's a different topic. Since this reference was made by Justice Oka, I think that the term used by Justice Oka about the political inclination, it was a very thought over term. I have no doubt about that. But taking a position on a national issue may not necessarily have a political connection to a particular organization or to a particular ideology. That's the view that we have been adopting all along. And for any person, including or any section of the society, including the lawyers, having a position on the issues of national importance is a very, very normal thing, natural thing. Keep aside this aspect of the matter, since the topic is about the retired judges of the constitutional courts offering themselves as a witness on the topic of the status or the fate of the accused being extradited to India and the consequence of that. There is one experience I also have had of being a witness on the particular subject as expert on Indian law in the Australian court. Subject was very a private dispute between husband and wife, and whether the divorce decree which was sought for by the husband on the ground of irretrievable breakdown of marriage will be recognized in India, and whether any prejudice will be caused if Australian courts grants any decree. So that was altogether a different kind of topic, and I had an occasion or opportunity uh, to experience this kind of proceedings in the foreign court. Justice Oak was absolutely right in saying that if somebody, maybe retired judge or anybody, comments upon in foreign court the state of affairs of the Indian judiciary, we also need to be introvert. We also need to look within what is wrong. And whatever the areas of concern that Justice Oak expressed, I substantially agree with him, I must say. However, the topic today perhaps needs to be again highlighted, and that is the propriety or the consequences of a retired judge of a constitutional court offering as a witness on behalf of a fugitive in foreign courts and expressing something about that. I must give a specific example of not necessarily that it's all about the actual factual aspect which is stated as an expert witness. In fact, Live Law has reported a judgment in the matter of Nirav Modi. The retired judge of the Supreme Court had deposed on that occasion. The statement or deposition which was actually recorded by the court is something that needs to be noticed. The retired judge practically, if I don't want to read that and spend or waste the time of this particular program, but the essence of the deposition was that a retired chief justice of the Supreme Court had some quid pro quo and got the membership of the parliament, etc., etc. Or that four judges of the Honorable Supreme Court had made grievance about the Chief Justice of the Supreme Court about allotment of matters, etc., etc. I think that these are opinions about what the judge felt. This is not about the state of affairs or the official reports of the government of India. There is other side of the story also. For example, commenting upon the retired judge about there was a background. The same judge had to face contempt, almost contempt proceeding in the court presided over by the same judge who later on became Chief Justice. So all these backgrounds also need to be taken into account uh, when we as Adhivakta Parishad look at the situation which emerges because of these kinds of depositions by the retired judges of the Constitutional Court. And in my view, I to an extent, I agree with Justice Oak that the resolution passed by the Adhivakta Parishad takes a bit of extreme position. But that extreme position perhaps is a very natural reaction of the members of the of the bar. We see a judge who has actually acquired the status, the standing in the society only because he actually occupied the office of a constitutional court, taking advantage of that, acquiring the position or standing, and then criticizing the very same institution in the manner in which in the manner in which perhaps the the retired judge should not be doing. You are representing a fugitive who is declared to be officially declared to be fugitive and who is sought to be extradited. Also sends a very wrong message in the society. And these are all aspects which also need to be borne in mind when we deal with the subject as a whole. But I again, as I said, I again say that I fully agree with Justice Oak that unless we correct whatever are the misgivings or whatever the shortcomings in the existing institutional working, the opportunity for such depositions are bound to be cannot be avoided, and therefore we must look within, we must try to improve our existing institution as a whole. That is the real answer to that. But at the same time, I think there has to be some way, some method, at least at maybe informally, by some consensus amongst the body of the retired judges, some consensus involved what way to go about when such requests come. And I think Justice Oak said about one thing, that after retirement I am free to go to on any forum, etc., etc. But I have doubt about one aspect of the matter. When retired judge takes a position, an extreme position, sometimes on issues which are seriously controversial, and the same judge had occupied the office of the judge, it creates serious doubts about the view which that judge took in that matter when sitting as a judge. It is because he already held this kind of ideological inclinations or commitments on this side or that side. So that also is an aspect which also has a bearing on the topic of the. I don't say that the judge who retires should be just keeping quiet, should not be expressing himself, etc., etc. But I think there are some codes of conduct which must evolve, that perhaps forum or the body of retired judges should evolve for themselves. Uh, on the whole, I feel that the topic that we initiated for discussion today is only a beginning, and it can't have any conclusive tones actually reaching in the discussion or at the end of the program. This is the beginning of that debate or discussion, which we should carry on informally at various levels, various forums, which may give some fruitful results in the time to come. With these words, I again thank you all for being present for this forum. Of course, as the persons addressing from the particular office, it's impossible for us who are the people who are the how many are the people who are actually viewing the program. But I hope that the good number of advocates all over India are actually participating. And I again thank Justice Oak for being part of this function of Adhivakta Parishad. Thank you very much.
Thank you so much, Navare sir, for those valuable remarks. We now move on to the vote of thanks. And it is also my pleasure to just inform the distinguished guest here that people across the country have logged in through YouTube, through our Adhivakta Parishad YouTube channel, as well as through Verdictum's official channel on YouTube. They are watching this program live. Now I would just invite Jyoti Tiwari ji to kindly deliver the vote of thanks.
On behalf of the Adhivakta Parishad Supreme Court Unit, it is my privilege to propose the vote of thanks for this enriching session of the Justice S. Parvatha Rao Lecture Series. At the outset, I extend our deepest gratitude to our esteemed speaker, Honorable Justice Abhay S. Oka, for delivering such a thoughtful, provoking, and principled lecture on the theme of robes cannot be rented. Your insights on judicial ethics, institutional integrity, and the responsibilities that accompany the office of a judge have been both illuminating and inspiring, sir. The clarity and conviction with which you address this sensitive issue will certainly resonate with all members of the legal fraternity. I also express our sincere thanks to our guest of honor, Senior Advocate Sri Vinay Navare sir, for gracing this occasion and for his continued guidance and leadership with the Adhivakta Parishad. Our heartfelt appreciation goes to the organizers and members of the Adhivakta Parishad Supreme Court Unit for conceptualizing and hosting this important lecture series, which contributes meaningfully to a contemporary legal discourse. I would also like to thank all the participants who had joined us today. Your presence and engagement made this session truly worthwhile and successful. Finally, we remain grateful to everyone working behind the scenes whose efforts ensured the seamless conduct of this online event. With this, I once again thanks all and extend my sincere thanks to all. Thank you so much.
Thank you so much, Jyoti. Thank you to our distinguished guest for today's evening, Justice Oka. Thank you everyone for joining in, and see you in the next edition of Justice S. Parvatha Rao Lecture Series. Thank you so much. Namaskar.
Namaste, sir.
Thanks to you all.